Hey there, everyone. This is Jim Hiles at Co-Plan 101. Today's Wealth Wednesday. We're talking about wills and trusts today. So yes, they're legal documents that basically it's your estate plan. But it's not your entire estate plan. It's a tool within the estate plan, and we're looking at the differences real fast here. So I'll walk through it verbally so people can hear it as well as see it. The difference between wills and trusts kind of set up on here. There's something called an effective date. The wills don't really become effective until someone dies. Now, you execute a will. It's something you sign, and generally you have a couple of witnesses to make sure that you are who you say you are, and that's your signature. But that's really doesn't come into being effective until somebody dies. The trusts are actually opened and signed and generally funded. Some nominal amount of money is transferred or created just to put in as an asset of this trust. When you go through wills and trusts, the trusts we're kind of focusing on here are what might be called revocable, or revocable trust is something that you can change during your lifetime. Let's talk about incapacity. Wills do not protect you during incapacity. Trust can. Wills do not avoid the probate process. Probate is all about proving a will, whether or not it was valid. Trusts tend to avoid the probate process because the assets are already transferred to a document or an entity, so there's no need to go through a probate process. It's already where it should be, so to speak. Wills don't preserve privacy, and this is going through the probate process where everything's pretty much open, and basically there's a statement that's sent out that says, hey, take your last shots at me. In a trust, you don't have that going on because the assets are already transferred, so therefore there's no process of proving. And frankly, it is a quiet process from a public standpoint. There's guardianship within the wills, but typically not unless stated within the trust. Typically, guardianships are assigned within a will, which is why when you have a trust, a revocable trust, you tend to need a will. Even though it might sound silly, you probably should have a will to collect any assets which aren't already put in trust and take care of things like the guardianship. Wills, I'm not sure what cost this is referring to, but it depends. It is relatively straightforward. You can get wills done up to $1,000. Generally, if you're talking about something more complicated, it could be more than that on the will side. Wills are a little bit different than trusts in terms of setting them up. You're essentially pre-doing your estate with a trust. So generally, it has more provisions and flexibility built into it for future possibilities. Contestability is another good one. Yes, as a matter of fact, the probate process is kind of designed to say, hey, challenge away, because that's really what they want to do. When you close the probate process and all challenges from creditors or whomever have passed the time frame, then that door is closed. When you have a trust, you're less likely to be challenged because it's an ongoing entity, and there isn't that same process of probate. Precedents, basically, wills are secondary to trusts if the trusts have been funded. And the other thing to keep in mind here is wills and beneficiary designations on IRAs and insurance policies and annuities. Wills do not control beneficiary designations. That's very important to understand, that you say, I got a will, I got it all taken care of, but the assets in your 401k are going to your beneficiary, which go outside the will. Protection from creditors. Wills do not, and trust can, depending on the kind of trust it is. And we'll talk more about that at another session. Next week, another episode, Wealth Wednesday. Thanks, Jim Hiles signing off.